As in reaction to the proposal by the Justice Department on some amendments to be made to the whistleblower legislation, and this process is now open for public comment. The proposals are based on already established laws in countries such as Canada, the United Kingdom, New Zealand, and some African countries that would include the likes of Kenya and Ghana, as well as Tanzania. Corruption Watch Executive Director Karam Singh joins us now, and he is going to tell us what their reaction is as opposed to this legislation. Karam, good to have you. Thank you very much for coming on. In part A is an acknowledgement or an observation, what they are saying, that the measures currently in place around whistleblower protection, particularly when it comes to the Public Disclosure Act, are not sufficient at present, and there's something that needs to be done there, certainly to tighten that legislation. Some crucial recommendations are being made, having looked at what is available internationally in the United States, as I mentioned, in the UK, Canada, Australia, and in some other parts of African countries. But here are some of the proposed amendments. One of them is that there's the definition of detrimental action is something that needs to be worked on. What is your view there as Corruption Watch?
Yeah, thanks so much, Tavo. It's interesting, after so much time has passed, that Department of Justice have released a discussion paper at this stage, as opposed to something that's more concrete, like a white paper or actual draft legislation. So at that level, we're a little bit underwhelmed by the development. But I think you're right. The paper does do some important comparative research, and is quite clear in saying that there are major deficiencies in the existing legislative framework. Problems around definitions around who a whistleblower is, what a protected disclosure is, what it means when whistleblowers get victimized. So, what the paper does is acknowledges that there's some shortcomings in the existing legislative framework, and then hints at the introduction of legislation which would rectify these issues. But it's just a real step in a process, and I think we know that the legislative process doesn't move that quickly. So there's still a lot to be done, but at least we're happy that there at least is some progress here, and we have a document that we can begin to engage with.
Yeah. If, for example, adequate protection measures are to be put in place, what would they look like? One of the suggested things that I'm hearing here is the establishment of a fund to support whistleblowers. How is this going to work?
Well, that's the same question that I had when I read the document, because the document speaks about the creation of this fund, but then it doesn't really give any very much guidance on how that fund would operate, on what basis whistleblowers would be able to apply to that fund. But this is something that we've been talking about for a long time, that beyond just having legal protections in place, we actually need to have some type of financial support put in place. We need support in terms of the legal advice that whistleblowers get. We need a clear institutional home within government that whistleblowers can trust, that they can go to when they need support and when they need protection. And these are, now the devil's going to be in the detail in terms of what we're seeing. So, a whistleblower fund could be something that comes out of the criminal asset recovery account, when we know that the SIU recovers significant amounts of money that's been lost to the state. A percentage of that money could go into a fund, and then presumably, a whistleblower would have to reach certain objective criteria in order to claim money from that fund. But, the paper at this stage doesn't give any of those details, so it's very difficult to know in practice what the Department of Justice thinks when they talk about the creation of a fund.
They talk about expanding, for example, the role of the South African Human Rights Commission in handling disclosures. For example, if the Commission decides to deal with a particular complaint and how investigators must be assigned, for example, who would be the people that would be duly qualified and so on and so forth. Does it go far enough in terms of what could be given as powers to the South African Human Rights Commission?
Again, this document doesn't go far enough because this document is basically just a research paper with a few very loose recommendations at the end. It's not really concrete. I have to disclose that once upon a time I was an official at the South African Human Rights Commission, and despite being a relatively stable institution supporting constitutional democracy, I think it's fair to say that the impact of the South African Human Rights Commission has been somewhat patchy when it comes to dealing with human rights complaints from the public. So one is a little bit concerned that this would be the institution where whistleblowers could go. But it could work, but it's only going to work with a real commitment to actually providing the appropriate resources and expertise to person this kind of capacity within the state. Oftentimes there's a bit of reticence at the moment about creating new institutions. One of the critiques of the Zondo Commission was, he proposes the creation of too many new institutions, and at the moment the institutions that we have don't function optimally. One of the reasons the institutions don't function optimally is that there's not sufficient resources given to them, and then there's not sufficient expertise that resides in-house to deal with the issues. So it's all well and good expanding the power of the South African Human Rights Commission, but we have to realize that with that will have to come a real commitment by government to say, we're not just paying lip service to whistleblower protection and support, we're actually supporting this by providing appropriate resources and providing appropriate expertise.
Speaking of appropriate resources and expertise, legal fees, I mean, if anything to go by what you've seen at Transnet and some of the whistleblowers at South African Airways, is that legal fees for representation are one of the issues that have been a sticking issue. And this particular report also points out that we are lacking as far as that is concerned, whistleblowers who are targeted. Yet, I read here one of the new provisions saying that during a legal proceeding instituted against a disclosure concerning a matter arising from a disclosure made by a disclosure, if the minister is of the opinion that the disclosure needs legal assistance, the minister must issue a certificate to the disclosure recommending that Legal Aid Board, in terms of the Legal Aid South Africa Act, considers granting legal aid to that disclosure. Legal aid, I mean, we're dealing with a matter, for example, of the public protector. Some other people suggesting, well, she must go to legal aid and get representation, and the court saying, no, she must get legal representation of her choosing. Yet for whistleblowers, it seems they will be handed over to legal aid if this new provision is put in place.
Again, Thabo, now we start looking at the details of what these things actually mean in practice, and we see that it's deficient, that it's not actually a viable recommendation that we can take forward. We know that legal aid is stretched incredibly thin, that legal aid really, battles to fulfill its basic mandate of providing support to all the indigent persons out there that find themselves criminally accused or, ensnared in the criminal justice system. We know whistleblowers have been made bankrupt by slap suits against them, by intimidation from employers. So it's good that, again, that the research paper identifies this as an issue, but we now need to go really beyond identifying issues and coming up with real, viable, concrete solutions. I mean, if we go back to the Zondo Commission, if we go back to the statements of the president, we know that we can't even think about fighting corruption if it wasn't for the courageous, in some cases selfless actions of whistleblowers that have really put themselves out there. Their careers have been destroyed. Their reputations come under intense scrutiny, and financially they face a serious backlash. So if we are going to really provide support against the kind of slap suits that whistleblowers face, then we need a much more kind of viable legal support mechanism than I think legal aid is going to be able to provide. So these are the types of comments that justice can expect to receive, and hopefully, this will then inform, something which is practical, but something that can actually really add value to the experience and lives of whistleblowers.
Karam Singh, appreciate your time as always. Thanks for coming on, Executive Director at Corruption Watch there.